I think we should get started because we'll quickly lose our advantage of having ended the first session a little bit earlier. Welcome everyone. I'm Sharon Press. I am a professor at Mitchell Hamline School of Law. But probably the reason why I was really invited was I spent many years, I don't like to tell how many any longer, but I spent many years as the director of the Florida State Court's ADR program, the director of the Dispute Resolution Center there, and we'll share with you a little bit of the different perspectives that I bring to this research. But I want to say that I was so delighted when I got the call from Jonathan to join all of you, because this research truly is amazing. So, and I am joined by two people who are the rock stars that you already know, and I'll let them say a couple of words in introduction first.
Hi, good morning. My name is Maureen Denihan. I'm the Executive Director of the ADR programs in the District Court, and I have the responsibility and honor of overseeing ADR programs all over the state of Maryland in the District Court.
And good morning, my name is Zuberi Williams. I go by Zoo. I know a lot of you want to call me Judge, and much to the chagrin of my colleagues, you can just call me Zoo. You don't have to, when you do hard work, you don't stand on ceremony. So y'all done hard work, do not stand on ceremony. I'm actually a District Court Judge in Montgomery County. Currently, I am the new chair, took over from Judge Wilson, of the ADR Subcommittee for District Court. And so I'm the chair of that as well. Before that, I was an ALJ, which I'll probably talk about a little bit later. Being an ALJ in the state of Maryland, you have to be a mediator. And a lot of people know that. So all 60 of the ALJs on all the different jurisdictions have to be mediators. So I was a mediator then. And before that, I was an assistant attorney general for DC, where we did lots of mediation in all my cases. So.
All right. So when Maureen and I spoke about this panel in preparation for today, we decided that the way we wanted to structure it was that I would start by providing some preliminary remarks, and then we wanted to gather from you, having had the opportunity to hear from the researchers and about the research design and some of the findings out of the district court. What were the things that piqued your interest? What were the things that you wanted to follow up on, or what questions you have, what issues, what follow-up, sort of the questions that Jonathan left you with that you were supposed to fill out in those pieces of paper that we want to gather from you, and then use that as our jumping off point to add our reflections and things that we think were really significant about the research. So we will reserve about 10 or 15 minutes at the end for each of us to have a few minutes to sum up what we think are the most important, in case what we think was most important hasn't already emerged, but I'm pretty sure that it will. So with your permission, I'm going to begin with some preliminary framing remarks. So first of all, I want to start by saying how delighted I am to be here. So I have personal reasons for being delighted to be here, and that is because my husband, who was basically grew up in Baltimore, kind of thinks of this as being home, is a huge Orioles fan. And so one of the things I did when Jonathan called was to check quickly the Orioles schedule. It's like, oh, they're in town, absolutely. My husband will join me, which he rarely does when I go on business trips. And so I thank you for the opportunity to be able to bring him to Baltimore so that we can go see a game. And last night we weren't at the game, but he was really happy that they finally delivered a win against those hated Boston Red Sox. Yes. So I share that with you. But most importantly, I was happy to be included because of the importance and quality of this research. I consider this research to be one of the most significant contributions made to our understanding of mediation since this grand experiment with the courts began. And approximately 30 years ago, which is really hard to believe. To underscore this and prove to you that I'm not saying that just to be kind or to suck up to having been here, 2 weeks ago, I was invited to speak at the Mediation conference in Hong Kong, and I was asked to talk about what was happening in the United States. Now, can you imagine, I was the person from the United States to talk about what's happening. And so I started by, of course, saying that it's sort of like the story of the elephant. Well, it depends on where, what you're touching. And so with some apologies if I was just giving my perspective of what was happening. But one of the things that I chose to talk about there was this research, because I do think that it is really the most significant thing coming out of the US right now. And the talk was supposed to be about trends in mediation, and the second was about the comparative benefits of evaluative versus facilitative, because that's a big issue for them over there. And of course, this research has just huge implications for being able to talk about that. So it was great for me to talk about, not only from my personal commitment and understanding of how important self-determination is in terms of mediation, but to have actually a very comprehensive, rigorous evaluation that really highlights how important it is for the mediator to be able to use those skills that highlight and really draw on party self-determination. So that is, was really a very, very exciting for me. So before I go further, I want to express gratitude to the Maryland Judiciary and the State Justice Institute for recognizing this need for the study and being committed to resourcing it so that it can be completed in such a meaningful manner. And I am willing to show you my remarks here that I wrote out to say, and what I said was, in my book, Laura Chakoudian and Holly LaChance are rock stars. And then that was the theme of the whole morning, was that Maryland are rock stars. It was like, oh, I can't believe it. That it fits right in there, and I can show you, prove that. And actually, my experience with the Maryland Judiciary goes way back, actually, when Rachel first convened the planning group to talk about what should Maryland do before there was even a macro. And I remember Marvin was in the room and lots of other people. And it was, I knew then that Maryland was going to go on and do amazing things. And no doubt, it's true. Maryland has. I think even I did not appreciate just how significant all of the work in Maryland would be. So part of what?
I just want to say that you not only were the first...
You're supposed to talk into the microphone, so...
I just want to say briefly that not only were you the first out-of-town person invited to speak to the ADR Commission, you advised me way before the ADR Commission was a reality of the things that you would do differently, the things that you appreciate that you did, the things you wished you hadn't done. You gave me the reason I think Maryland was able to go forward quickly was because we had the advice of people who had been on the front lines for a long, long time, like you.
Thank you. It means a tremendous amount to me because, as I said, I am a huge, huge fan of the work that you all have done. So thank you for that. And really, it's the leadership, the vision, the support of Justice Bell, Rachel, and all of you who have contributed to really what has been going on here. So, and in terms of this specific project, it didn't just happen. Like all of Maryland's ADR work, it began with an extensive lit review, studies which had previously been conducted, a gathering of researchers who had worked on or conducted evaluations, looking at what did they wish that they had done differently, what did the research tell us were the holes, what did we realize as we went into this research, by the time we got to the end of it, that we missed along the way. And so the goal was designing an evaluation which would advance the field. From there, the Maryland team set out to design, implement, and then analyze this amazing research project. It is my hope that in Minnesota, where I am now, that I will be able to replicate it. And I was delighted to see in the report that there is a statement about the importance, one of the limitations being that it is a unique study, and that there aren't a comparative study to really support it. And so I think that hopefully will help me to generate some funding to do that, because this kind of research does not happen without that kind of strong funding. Finally, what I want to point out is that with most things, each of us see the world from the perspective that we bring to it. And so I thought it would be important to think about what are the lenses that we are viewing this research with. And so for me, the lenses that I'm viewing it with are, as a mediation practitioner, as a law professor of mediation and a mediation clinic, of which my students go to the equivalent of district court to serve as mediators, and a mediation trainer, and then a former administrator of the state court connected ADR programs. And in that position, I was responsible for mediator certification, training, the grievance resolution, advisory ethics opinions, and procedural rules. And so there's also this sense of what are those qualities, qualifications of mediators, and what does this mean to us as we think about not only running our programs, but also what the mediators need to be doing. So with that, I'm going to pause and come out to all of you and ask, so what are those issues, the things that, from the very quick overview of the district court study, that you want to talk more about, that are implications you see? And we're prepared to add more if you don't. So, ideas, thoughts, questions? Yeah.
Sharon, one of the things that struck me was the impact of caucus, and how it might be giving us kind of individually feedback that says, hey, this is great, I'm spending time and the parties love me, but maybe it's negatively impacting the long-term results for the parties. And so that's something that really stood out to me.
Yeah, really interesting stuff. Okay, we'll collect a bunch of them and then we're going to come back and talk about them. Others, yeah.
I just want to say, backing up Julie, I just want to say how important that is, because so much of commercial practice now is done in caucus, and some things that they call mediation are entirely so diplomacy.
Right, yeah. So one of the things that is a U.S. trend is the death of the joint session, and this research is really powerful in suggesting why that is not a good trend to be going on. Other?
You guys did a chord for me. And I think we don't.
I think it's all. Got to talk into it.
We don't need to go there, but it's like the why. The why with respect to the death of the joint session and who has pushed it there, and it's there now, and I think this may be a way to kind of bring it back to a certain extent, because there's some folks who are adamant against it, and in the International Academy of Mediators, I don't want to get too into this, but there's some mediators who would like to do it, but they're afraid because that's their income, and people, the gatekeepers want it a certain way, so that's what they do. So that's all I have to say about that.
Yeah. And, I'm wondering whether you want to say something. So now there's been a couple of comments about caucus, and whether either of you want to say anything about that before we pick up another piece.
Do the full response we were thinking of?
Yeah, because there's a lot of energy
Yeah,
around this
I had at
topic,
least
so we
4 comments.
decided to be kind of fluid with how we would run this.
Right, right. So at least 4 things came up for me as a program administrator when reading the results about caucus. The first has to do with the quality of the services the practitioners are providing. And that for us is a best practices quality assurance issue. It could be a training issue where we need to go out and observe our practitioners and talk to them about when they use caucus to really better understand when you're using caucus, why are you using caucus? And these results in particular speak to that caucus isn't a bad thing, it's a thing, and how much time you're spending in caucus, the impact that it has on the participants. The other piece of that goes to the education of the practitioners and of potentially the bar, right? Because the bar or the attorneys representing their clients might be driving the fact that they want that private caucus, that they want that one-on-one conversation. So there's that education component also of educating the practitioners of the effect the more time you spend in caucus, what it not only has on the result, the participants and the perceptions they're feeling about the process they engaged in and their perception of the other person in the process, but long term, they're coming back to court on those agreements. And that effect has on our time case standards, right? On the district court and how we're managing our caseload. And then I think the last piece was, what is the transferability of these findings? I think that's a limitation we don't know right now, from the district court to other settings. Can we transfer the information we've learned here about caucus to the commercial setting or to circuit courts or to other settings where we have ADR? And I think that's one of the limitations of the study. We just don't know yet.
Well, sitting from the judge's perspective that I guess I'm giving here today, I mean, there's a lot of different, I mean, I can sit from either the mediator or the practitioner, but from the judge's standpoint, one thing, and this may not be a popular thing to say, but one of the criticisms I get from my colleagues is about how long the process takes when you're on the bench and you're getting through cases and you want to know what's the status of the mediation, you know, can I work on something else, can I take this trial? Going back to the caucus, it seems to me that the longer that you're in caucus, the worse the long-term effects can be, things of that nature. It makes for me, that I want to say is, well, what's taking so long? Are you caucusing? What's going on? Oh, well, you know, if you caucus too much, you know, that may not be good for the overall process. So for time management with regards to what's happening that day, I could hear my colleagues, and I can understand that. It's not my view, but it is a view that I could hear from my colleagues saying, well, you don't need the 2 hours, right? You don't need the 2 hours, you don't need this, you're caucusing. Study has shown that that's not beneficial, you know, let's try to pare it down. Now, from a different standpoint, I think that, that caucusing, when I did it, was easy way for me, not easy, a good way for me to do 2 things. De-escalate whatever conversation was happening between the parties. If we got in there and it was a hot-tempered mediation, I often relied on caucus to kind of de-escalate everything. So that's one reason why I did it, and I had some success with it as well. As a practitioner, as an assistant attorney general, whenever we did the caucus, I did that for client control. Mm-hmm. That's one of the reasons why it was effective for me to do that. So even though that I see the direction of where the mediation is going and what we're suggesting, for me, it was an opportunity for me to kind of get my client away from, you know, and say, well, this is this is that. Listen to the mediator. These are some ideas. What ideas we can come up with and go from that point of view. So those are just kind of the 3 ways that, from my practice and what I do now that I can see. I'm not so alarmed. I don't want people to get alarmed that, judges are going to run in there and say, this is the reason why we need to have shorter mediations. I was just saying that it is a result. And judges were lawyers, and they make arguments based on facts, and so hopefully based on facts. So those are some of my general thoughts, but I'm open to other suggestions. But so from judge, mediator, and then practitioner, those are my general views.
So before we move on to another topic, is any other kind of discussion point around caucus that folks want to have?
So when I was out in Prince George's County, I handled all the settlement conferences for any judge could refer them, and I would sit at noontime over lunch. And I only had an hour-long period, and this study has showed me, I used almost exclusively the caucus method. I knew of the other methods. I just never bothered to mix them in really, because caucus for me in a settlement type of negotiation was the most effective and time consuming. I only had an hour because I had to get back on the bench at 1:15. But what the impact of this study has showed me, and I was down here 2 weeks ago for a negotiating run by CDRUM and Macro, is that there's times to strategically think of what type you want to use at that given time. And I never really thought like that before this past seminar that I went to and this study. And I think it'll be very beneficial. Most people would like to know that they can run between styles to try to make it work the best way they can.
Yeah, and I think it's important to note that, Maureen said it, but just really to highlight, it's not to say that one should never caucus. It's the percentage of time one spends in caucus. And, whoops, I have 2 microphones, so I should use one only. Yeah, right. You really only need one. And so it's really to be very reflective about what is going on in the room. And it makes sense when you think about it that someone would report feeling less capable if their lawyer is controlling them by having them in caucus and having less control over the situation. And so it's not surprising, but it's really helpful, I think, to have the data and the fact that then people aren't as satisfied with what happened with them and they'll come back. And so for courts, I think you need to think about that piece.
I think in terms of discussing caucus and enlightening the ADR community about the fact that there are pros and cons, one effective way to help raise the discussion and raise the level of understanding is to maybe compare it to how litigants feel when their lawyers go back in chambers and talk with the judge, and that's where the lawyers are, and then something happens. And there seems to be less satisfaction with the court system when there's a lot of stuff happening behind closed doors. So I don't think we should be surprised that the parties don't have the same level of confidence when they know that the other side was back behind closed doors with the neutral, and then they're back behind closed doors with the neutral. So I'm only raising this as you're trying to raise everyone's level of understanding about how it can be negative. I think most of us do understand that the chamber's conversations already raise a level of distrust. So this is a very similar issue in terms of the distrust feeling.
Absolutely. My first job in the ADR field was working in a New York City public high school running a mediation program, and we never, ever, ever used caucus. And the reason is for the very reason that you've talked about, Judge, that if the distrust between the students were so high that if they came out of that separate meeting and were saying something different than what they were saying before they went into it, it'd be like, nah, I don't believe that, and so they needed to actually see the change. They needed to hear it for themselves, to see the light bulb go on over their heads. And you lose that when important stuff of shifts happen, but they happen behind closed doors of the caucus. Yeah.
One other thing, I think it has, a possible implication that mediators who rely on caucusing may not have the skills to do the reflection, eliciting work of mediation, because I think caucusing it's easier for the mediator, to just split them up and make a deal than to really use those skills. So I think training implications about having more skills learning in reflecting and eliciting for mediators.
Yeah, and that's a good point. It's much easier to tell when you are in caucus.
So to follow up on the theme, one of the soapboxes that I've had for years is the distinction between mediation and settlement conferences. And in Maryland, we're fortunate that those processes are both defined in our rules. I know not every jurisdiction, every court system around the state has, around the country, has that same distinction that's clear. So sometimes in other locations, the processes get blurred and they're often just called mediation. One of the things that so what I'd like to see next, along a similar theme, is to try and figure out, and Maureen kind of touched on this, try and figure out if there are certain kinds of cases, driven by attorneys or not, where separate sessions, caucuses, settlement conferences make more sense than mediation the way we were taught mediation. That maybe we shouldn't blur the lines, maybe we should define our terms and then try and figure out which forum the fuss belongs in. And that's where we started back in 1976 at the Pound Conference. It's not, not my idea, but maybe we need to start looking back and trying to figure out which cases would be better in a process called settlement conference, where what's important is a settlement that everybody can buy into, versus mediation, where maybe rehabilitating, rebuilding, or preserving a relationship is more important. So I'd like to see the next bit of research touch on that.
Yeah, so, and Marvin's got some.
Can I add to that for just a second? That also goes to educating the users and the community, so that extends beyond the bar to the litigants about what their choices are. So then they can make informed decisions, because maybe that's exactly what they want. They want the caucus style, and I think, Marvin, you were alluding to that before.
Basically, and as Jonathan knows, because he reviewed it, I wrote an article on this about how all these processes are pushed into mediation. Mm-hmm. And so the public, they don't have a clue. So they go to a mediation and they get this, they go to a mediation and they get that, and they're all confused about their experience in mediation. And so that if we're able to, what I tried to do in that article is to say, if what Jonathan said, if we can distinguish these things, and hell, we're trying to educate the public. We can't even educate ourselves as ADR professionals. If we can do a good job of the training and education on our side, it'd be easier to educate the public, because Rachel, you guys know, Marilyn, I've been banging about this education thing isn't working. We've been saying we're going to do this, and what we've tried hasn't happened. But we've got an internal issue. We've got an internal issue yes. that we've got to deal with, and we are diverse. And sometimes we get used to, if we're trained a certain way, or I wrote another article about how folks, depending on where you come from, it becomes your mediation style, and that becomes your focus, and you continue on, and then it gets into the work I have to do for Lewis, president of ACR, about diversity of practice. Well, the way I do it is better than the way you do it, and the way there's a use for each of them, and kind of what they said up front, there's a use, but understanding when to use it, when it's appropriate, is very important. And not everybody can do that because they don't experience it, they don't have the training, and they don't understand the nuances of how to do this work, which is very important. And I think that's why we have stalled a bit in terms of our progression as a profession and as a field, because we've got these things that are sitting out there, and people just, I think we're in silos. Different groups in terms of the way they practice and what they do, that we're charging ahead without coming together and making these distinctions that we're talking about. There's enough for everybody. It's, like the bigger pie, it's we don't practice what we preach. It's there, but we just don't get to it. I'm sorry for taking the floor for so long, but I'm passionate about it.
Yes, I do. Yeah.
My comment or question is really a little bit different about the impact of caucus. It's more about, and maybe I missed it in the study, is the unmet need of those individuals that otherwise could have participated in an ADR process, but because of lack of resources, no ADR or mediator available that day, or a settlement conference officer, or a case being not heard till late in the day, and no one's there to hear the case. And on the early end of it, at least I know when I practiced in the circuit court, you had a box that you would check off, yes, I would like to participate in ADR, and that would signal to a party that at least this could go down that track. In the district court, we don't have that process in early resolution. And so those are things that I think I would like to see, because the unmet need helps us determine sort of the growth of mediation within the district court system. This information in the study is great for helping to fine-tune, train, educate, and otherwise work within the mediators themselves. But from the court, at least from my perspective, sitting there, I want to be able to schedule from the administration standpoint to make sure that we're maximizing the number of parties within the process.
Yeah. So Maureen, do you want to respond to that? And I think Toby also wanted to jump in on that.
Yes, Toby, will you do landscape on that at all? No?
I wasn't going to talk about that, but you
Okay.
can fill in whatever.
So a few things come up for me in the study. One, that's definitely a limitation. It doesn't address the places where we're not meeting needs, and we don't even know what the needs are, right? Because we're not tracking currently who has a desire to want to participate in this process. That's just something that wasn't measured. But what the study does highlight for me in some other areas where if you've read it and you learn about, you've heard about racial match, and you have learned that if you compare that reflecting and eliciting strategy together, presumptively, at least in practice, we've had this experience, those type of strategies take a bit longer than doing a caucus model or a directing, offering, telling type session. And so if we need more time for the sessions, to provide mediation or ADR earlier in the process. So the study was limited to just day of trial, right? That's another limitation on the information. And to look at if we can make changes in the way we offer services. We do have pre-trial offerings, which might give a wider audience access to services than are currently available in the day of trial program. In my mind, this highlights the need for expansion of those pre-trial programs. So that might be one way in particular that we could address the lack of access to those services.
And I was going to pick up with Judge Zuberi. What really, as I kind of been thinking about this for a while now, is that the real opportunity, I think a lot of the stuff, particularly in the district court, is I see with a lot of the intake and getting people to the process. And that really we can be using the findings and the research to help people make decisions about participating in the process. And a lot of that depends on whether a practitioner is available that day. But I don't think it's a surprise that people are resistant to sit down with somebody that they're in conflict with and talk about things, right? Especially when they already came to court for a judge to hear their case that day. But being able, as we explain the process, to tell people that, we're finding that you will be less likely to come back to court, that you will be able to talk about and hear, the other person's likely to gain a better perspective, what we're finding just by participating in the process. And I'd really like us to start integrating that as we're talking to people, both from the bench, from the practitioner community and the ADR office.
So let me say something about that from the bench. I think that's right. For me, and I don't get to see all my colleagues all the time, but the push has got to come from the bench too. It's got to come from a judge articulating what exactly ADR is, mediation is, who are these folks who are sitting, to my left, what is the reason they're there, what can they do? I think that when you try to, get on the bench, you go watch a bunch of other district court judges, so you can say in your interview, I watched a bunch of other district court judges and this is what I think. But one of the things that I've noticed, without naming names, is that they would just say, this is an option. This is an option. If you want to do that, it's an option, it's there, that's it. I have a little script that I say that's a little bit more, it may take 2 to 3 minutes to say it, it's taking up time on the front end of my docket, and remember, I'm just focused on what my colleagues might be thinking about time issues of trying to get cases in and out on that day in district court. But I take some time to explain to them, and folks who've been in my courtroom, Gretchen and other folks who've been in my courtroom know that I say this is why it can be helpful. This is why it's important. These are the things that you can say that you might not be able to say in court. You can come in. So I have like a little speech I prepared. The study, which is why we're here, gives me additional things to say about whether or not they're going to be ultimately satisfied, things of that nature. And so I know that it is a part of training the personnel, but a part of that also is getting judges on board to to say more than this is what this is, which can be difficult when they are set in their ways. But that's something that I do. So I just encourage judges to do that. Maybe getting other judges who are believers. I see Judge Wolf's here. Other judges to kind of push their colleagues to do so. But it's just not just with the mediators or the ADR volunteers. It's the entire court trying to push for it as well. That's my view.
And can I chime in on what Judge Zuberi said, and I'm going to pass it over to Judge Cooper. There are so many points of contact that potential participants have with the district court that to get that early involvement might mean broader education amongst different types of court personnel, so that when a potential litigant comes to the counter and is thinking about filing that lawsuit, there is someone available who can start right then to talk about all the wonderful benefits of ADR and start to plant that seed at the initial contact before it even gets to the trial date. Maybe with a commissioner, when someone's going to file that statement of charges. And I know we're going to have a session later on about the criminal end. At that initial point of contact is a beginning to educate and orient and acclimate that potential participant so that they're mindful and aware, and we can start that process of getting them involved in ADR really early on so that by the time it's in our courtrooms, folks are familiar with that term. They have some awareness of what it means, bringing in all the wonderful points of this research to help support why it may be of benefit and of interest for them at this stage, that meaningful point when one needs to make the decision about what's going to happen next. That's the point when we can bring it all together and make it the reality for the person to make the choice to pursue mediation or ADR. I'll pass it over to Judge Cooper.
So 2 points. One, to actually expand on what was just said by Judge Wilson. The Harford County Community Mediation Program made a decision to do some really intensive outreach. And among the things that we did at the beginning level was to get out and to speak to landlords before they started filing landlord-tenant cases to learn what mediation is. We also prepared a video for the sheriff's office, which was part of their training, every roll call training to every officer, so that they understood what community mediation was, so that instead of telling litigants, go see a commissioner, go file a peace order, go file a lawsuit, a replevin action, to use mediation before they even get to the courthouse. So clearly, I think the court's partnering with those other agencies that are involved in what eventually gets to us, I think will go a long way toward getting the mediation process started early on.
Did you see a change? Did you actually see a change?
Well, these things we are doing, we have just started doing, so it's really just been maybe, 6 months, Jonathan? Maybe less than that, since we've had the video prepared. But really encouraging the sheriff's office to think about mediation before they're thinking about court commissioner, before they start thinking about peace orders. The other thing is, I had the good fortune of taking the mediation training a few weeks ago with some other judges. One of the big pieces I left with was understanding that when I'm on the bench and I run out of cases and the case that is out mediating, I want it back in my courtroom because I want to get started on the trial, is really a bad practice. And I've shared that with as many colleagues as I possibly can. But beyond that, now, and I've spoken with my colleagues, to think about, well, if they're out mediating, why don't you let them mediate through lunch? Why don't you tell them that you'll be available at 1:30 when we do our afternoon docket? It's okay if you would like to continue to mediate, and we'll find you a trial date on another day if you want to continue this process. Instead of asking folks that are already in the process of doing a mediation to come back into the courtroom because we have a structured schedule. And I think that really goes back to judicial education and changing of judicial attitudes to understand that the process of mediation in the long run will be more efficient and effective for not just us, but the parties. They're going to feel better about it in the end.
I think you're right about that. I just want to chime in on that last point. I think you're exactly right about that. That's the way that I try to do things. I try to put it in the practical setting of when you're on the bench and it's coming out, and you don't want to say what's going on, But a lot of the judges that I've spoken with don't know what's going on out there. There's no status check, there's no nothing. And so what you don't want to do is have the mediation go away to 3:30, you have to get through your docket, next thing you know it's a trial, it goes through, you're trying to manage it in a certain way. That not knowing is problematic. So some judges will say this, go get them to tell them to come in here. And that disrupts the process. Or some judges will send their bailiffs and say, can you find out what's going on? That disrupts the process. The time that the volunteer has to get up from ADR, address questions from the judge and go back in, you could be closer to finding a solution and coming out. But we have to find a way to communicate to those judges, because I'm all about changing attitudes and bringing new, fresh attitude to that. But at the same time, I think the complaint is real, that it's almost lunchtime, I don't know what is going on. And so there's got to be some type of, here's what's going on. I'm not sure, I know that's probably not popular, but it is practical, and it is something that we have to figure out a way to deal with.
Yeah, and I think to bring it back to the research, eliciting and reflecting takes more time than telling. And so that's like, a major piece for me that comes out of this research, and really, the practicality of it and being able to share with judges, yes, it takes more time, but you will reap the benefits in the long term. Both the parties reap the benefits, and the court system and the judiciary and all of that also reap benefits by allowing for the process to sort of progress as it will, and then really needing to sort of think through, and then how to support judges. I love the idea of, okay, so you go to lunch and you then come back and you get it, or you rethink how dates are scheduled for trial. Does it have to be day of trial, or can there be another way?
So to address Zoo's last comment, and you can't just say Zoo, you have to say it with some kind of flair, like Zoo. That's why I asked you to become the chair of the ADR subcommittee, so that you would come up with a resolution for that issue. So I'm relying on you for that.
Thank you.
But I'm very interested in all the points that you brought up against earlier intervention of that. And that's ADR is part of it, but it's a broader idea, and we've started to implement it already with the self-help centers. So a clerk may not be the best person. They've got a lot of things going on, and they're not trained to the level to understand, all the benefits and things. Maybe we could go that way. That is an avenue to go. The way that we're presently going is that we have 2 self-help centers right now that are staffed by legal aid to provide those types of questions that you may have in filling out your forms, or what you can expect in court. And I think they're doing an exceptional job of that. We have a 3rd one that's planned for Salisbury that's going to open this summer. We have the Catonsville Courthouse for you in Baltimore County. That will be built with a self-help center in it. We hope to get one to Baltimore City. I've been trying to get down to Baltimore City to see if we can space is a huge issue sometimes for the physical part of it. To get one in Baltimore City, and then to get one out in Western Maryland. So I have coverage all the way across the state. So the idea is that when the clerk comes in, one of the available, it's on an app. We're going to advertise on bus, stations where you sit, to try to draw people to this self-help center. And the self-help center routinely then refers people to both community mediation and to the same-day program, because it's wildly ineffective to do it on the same day. But to require individuals, the first challenge that we have is it happens very quick in the district court, right? There's not a whole lot of time to intervene in between those. And then the second is that the majority of the cases go by affidavit judgment. The defendant never responds and never shows up to the case. So you really don't know who's going to be at issue until trial date in a lot of instances. And that's why we're very flexible with, at least I was when I was a judge. You're basically going to get a continuance. Well, you were going to get a continuance the first time up if you were the defendant and you hadn't filed a notice of intention to defend. I was going to tell you, try to go get an attorney, go to the self-help center, wherever. So hopefully what the first contact would be a referral to the self-help center. And it's not just a physical presence, it's chat, email, and online. And then they can direct you then to the appropriate mediation at that point after someone with legal training has explained what the benefits of those all are. So that's hopefully the goal that we're going to.
Great.
And to use technology too on that, to be sensitive to the fact that people don't like to come to court and they have transportation issues. The more we can leverage technology to that, we're building an infrastructure to be able to do those type of things.
So I want to take a stab at trying to tie together your comment about Salisbury and having a self-help center there, your comments about allowing people to mediate through lunch, and Judge Williams, your comments I can't do it. Your comments about zoo. They're not booing, they're yelling zoo. Your comments about the judges wanting to know what's going on. When I first moved from Macro to the district court many years ago, we met with Judge Wade in Salisbury, one of our district court judges, who was an early adopter of, okay, this ADR stuff is okay, but I have questions. And we met with him, and he said, the question was, can we have 2 hours of uninterrupted time instead of the bailiff knocking on the door every 15 minutes? And it was the mediation program down there that said to do this right, we just want 2 hours of uninterrupted time. I thought it was a long shot that they would get 2 hours of uninterrupted time. But Judge Wade said, tell you what, I'll give you 2 hours of uninterrupted time if at the end of that 2 hours, you come out and give me an update of the status. I'm not saying end the mediation, I'm simply saying give me an update. And then if you want to mediate through lunch,
do that.
I'll go get my lunch, I've got chambers work I can do, keep doing what you're doing. But I need to know what's going on. I need to know the status. I have to have a feel for it. Here's my point in tying all of that together. That doesn't happen without a judge expressing to us, trying to design a program, what are your concerns? What do you want to know? And just to top it all off, because we're building this big old ADR program Sunday that we can all dive into, right? This doesn't happen without this research allowing us to have this conversation and say, gee, if the judges have these questions about what's going on, maybe we need to reach out to our judges more and say, what do you want to know? Do you want to be trained? Do you want to know what's going on behind the closed doors? How can we help you so then we can take what your concerns are and build a better program? And it all just ties together like that.
So before you hand it to Marvin, I want to note that this side of the room has been quite active, and in fact, every single person on this side of the room has spoken, and this side of the room has been very quiet. So I just want to check in. Is there anything that anybody over here wants to say? Oh, see, you were just waiting for an invitation. I didn't realize that. I'm going to start here, and then you're going to pass it to Jim.
Sure. Well, we were just trying to give deference to our judges over there and let them speak first. No, and I'm fortunate I've got two of my judges here, and it's both sides. I've got an AM program in Hartford County and a PM program in Baltimore City. So in Baltimore City, there you go. In Baltimore City, we don't have the advantage of saying, let's just mediate through lunch, because the courthouse is going to actually close its doors at some point. So for us, I think what I've tried to work out with the judges or communicated with the judges is just let us know. You can't in the midst of a session always say, oh, this is definitely going to settle, because we all know you're writing 2 or 3 pages of an agreement and then breaks down and people walk out. So I think to just say, what time do you need this back in order to have a trial? I'm not saying the trial's going to happen. I would love to be able to resolve it for you, but just tell me how much time. Do you need it back at 3:30? And that way at 3:30, I can relay that information to the participants up front and set some expectations about the session to say, I know from my judges that they want to know what's happening at 3:30. So it's 1:15 now, we've got an hour 15 minutes. Or it's 2 o'clock now, we've got an hour and a half. And that way, it's not a surprise when at 3:30 there's a bailiff or a phone call just to say what's going on. So I think it's helpful for us as practitioners and also as kind of program administrators to be able to say to our judges and also to our practitioners, let's just set a time that this check-in's going to happen. And that way,
everyone is clear. We explain to participants up front, and we know how long we have for that process. It's not the 2-hour window necessarily that's set up on the Eastern Shore, but it's still something similar so that everyone's on the same page about how the program's going to operate, and then we can share that information to our participants as well, so it's less disruptive when it actually happens.
Right, and the importance that we all know is communication and conversation and sharing of what are the interests and trying to figure out creatively whether there are ways to meet these interests. And again, having this research as a backdrop to it. Do you want to pass to Jim?
Thank you. I have questions about the telling or offering strategy. Sharon and I were involved over 25 years ago in a study in Florida. And the amazing thing to me is she still looks the same. I don't. I don't know how that happened. Where we were at the circuit court level, which is pretty much the same as circuit court here, and the people that used that particular strategy, we called it bashing, were the former judges. And I wonder if you guys are finding out if there are sort of residual findings, for administrators in particular. I mean, what kinds of people use the offering or telling strategy? And we know that it doesn't have any short-term effect from your findings, but it does have some long-term effects, and they're negative. And are you inclined then to do anything about that, training-wise?
Yeah, do you want to start on that?
That'd be great. So just to be clear, the offering telling is not a grouping, is not a description of a type of mediator. That these findings really talk about the groupings of how the strategies kind of fell together when they got shoved into stata and were reported on, right? And I think I could make a sweeping generalization, but I would be careful to do so, that type of strategy might be employed by those who in their former life or their current life are practicing attorneys, and they are familiar even seeing that strategy typically in the mediations or settlement conferences that they've attended, and it's been used very effectively. So that might be a class of people if we were going to make generalizations. But it is a training issue for us because in the district court there are 3 types of mediation frameworks as mediators have self-identified themselves that they fall into that we accept as practice in our program, and they do not include a framework where you would tell someone what to do or that you would offer them what they should be doing under the auspice of mediation. But you could do that in a settlement conference. And so there are mediators that practice in those other frameworks that permit that type of strategy to be used in the private arena and in other areas or courts of the state where that's an acceptable practice. So for us, it would be a training issue. It means taking our time when we do our 8-hour volunteer orientation to be really clear about setting expectations of how you mediate in our program, and then putting folks through a very rigorous, we think, apprentice process and giving them feedback regularly even after that apprentice process. So making sure we're watching practitioners and giving them feedback. But it also includes sharing the research with them and what we're finding.
One of the reasons I ask is I always thought that strategy looks very much like adjudication. And so mediation sort of loses its distinctive quality to the extent that you're using that strategy. And in a training context, I think I'd want to bring that out.
Thank you for that.
Anyway.
So wasn't there, okay, in the back. Okay, and this might be our last comment before we do our kind of summary. No, I'm gonna come back to Marvin for the last comment before we have the last comments.
I think that the theme that I'm hearing is how do we introduce our clients to the potential of this service? And that intervention can take place, as Judge Morrissey has indicated, by referring people to our self-help center. But certainly, we need to look at our literature, our brochures, and our information that we give out to people. I happen to be the administrative clerk for Baltimore City. We hand out brochures all the time. We need to update our information to offer mediation with an explanation, a simple explanation as to what it is as an option for people to consider. I understand Judge Skirty reminded me that there's a committee that is working on revising our brochures and our forms to put them in plain English, which I hear people say all the time. They didn't understand the lingo. But if we could just begin to add that, as Judge Skirty indicated at Circuit Court, it's a box that you can pick, you can select if you would even like to consider it, and add as a routine some kind of simple explanation as this as an option. We're not asking the clerks, and we know we can't have them give legal advice or even suggest something that looks like legal advice, but there are our self-represented litigants now who are taking greater control of their interventions with the legal system, and they would take the time to take a look at this information and consider it as an option. And I think that combined with some of the other things that we've suggested would go a long way to helping to educate our users that this is an option that's available.
Yeah, I love that there's all these different perspectives in the room, and you can see that for each of you, you're taking this research and seeing it from your own lens, which is great. Okay, Marvin.
Thank you. I'm going to keep it short. Since you didn't want to give me my intro place, I'll keep it real short. And I think this goes to the self-help centers, because I think this relates to this, and Toby and I were talking about this, and I think this goes to ADR in general. Intake is so important. Intake is to me, it's almost more important as getting into the process. And it kind of helps people know where they need to go. And tied to that intake, it should be someone who does know about the various processes. So it should be someone who's trained enough to help people, give them ideas on where they need to go. Also, with respect to the intake piece, goes with what was said earlier, the publicity of the programs and where they are and how to get there and how they work. All this goes hand in hand, and I'm very pleased to see this is coming together in the state I live in, and hopefully we can take it to another step.
Yeah. Okay. Thank you. All right. So why don't we start? Judge Williams, do you want to start with sort of some summary comments about what you want to make sure that everyone leaves here with?
I think pretty much everybody understands that sometimes judges are set in their ways, but you have to know that but you have to know that, and this is just hopefully encouraging words, is that there's, the effectiveness of ADR and the effect it has on people matter to judges. Long-term beneficial effects, especially right here in Maryland, I think more so than any other state, in my perception, matters. And so when we get information coming back from these types of research surveys, it can change minds in that it can open up other opportunities for us to do what we want to do. Judges want to be efficient in their docket, but if they know that the long-term effects based on the study mean something, they know that down the line it's going to be helpful. That is something that we can tell judges, that I can tell judges when we're in there, that all the admin judges who are here can tell judges, and something can push from that. I think that one of the things that I want to do, and when I got appointed, is make sure that the district court judges are well informed about what's going on here, and so that when you come to have a conversation, it's not the first time they're hearing it, and that they don't completely block it off. So know that that's some of the energy that the committee is putting together. That's some of what we're trying to do and push, and we're using the results of this study to help do that as well. In that vein, one of the things I liked about this conversation is that you got a lot of different views from all the different sides of the equation. And so we're always going to be open to new suggestions, and we've been open to older suggestions that may have not worked at one point in time that may work now too. So I think it's been very beneficial, in my estimate, from the bench.
Thank you, Judge.
Yeah.
Go next?
Yeah.
Great. So for me, the question becomes, now that we have the support of this empirical research, how and where can we appropriately institute more institutionalized ADR into the district court's processes, right? So the question is, do we want to do that with a check box on the complaint form, Jonathan Rosenthal, for 10 years now? Do we want to have all cases, as soon as they file their NID, be flagged to be offered ADR as a process, right? Are we going to start using the court rule where you can order cases to ADR, whether it's before the trial date or on the trial date? We can look at training for court staff, of course, depending on their role in the judiciary. Would it be appropriate for their position to need the information to share with the public? But there's also this education and information sharing that has to happen with all judges, not just those that come to a mediation training or get to serve on a district court ADR subcommittee. And that's very successful when it's done peer to peer. So as we all go out as the marching ants with this energy behind ADR, the judges in particular, when you share that information with your colleagues, it carries a lot of weight. And then there's the idea around initiating conversations with the bench, with program administrators, around what your expectations are with regard to what processes are offered in your court, when they're offered, who they're offered by, what types of practitioners, and then timing of ADR processes. Each judge is going to have a different perspective on how long I want this case to stay out, and then sharing that information with our practitioners. There's also the important distinction that we've been trying to highlight for years, this very thick, dark line between a mediation and a settlement conference. I just wanted to add, for those types of mediations that we don't acknowledge to participate in the district court's programs, those would be analytical or evaluative mediation. We would say, at least the two of us right here, and probably the rest of the district court staff, those types of mediation that you're referring to that do that offering telling, we would actually call those a settlement conference. So it's really also talking to the community, whether it be our practitioners or our court staff and judges, about the types of ADR we provide in the court. And then finally, for our practitioners, really knowing what we're doing and why we're doing it. So coming back to the mediation strategies research on the effectiveness. What are our practitioners doing, and sharing with them the research and seeing how, if they want to make adjustments to their strategies that they're using in day of trial, and then talking through them with their concerns, right? They might say, I don't have enough time to do reflecting and eliciting, and that's why I default to, after I get the first knock on the door, we're into caucus immediately, and it's really effective for me. The participants seem to really like it. And then remembering that the party surveys that happen after the session is only a snapshot in time of what participants think, and to know as an administrator, that's not the full story. People might walk away with this feel-good effect of what happened, but I don't know what's happening 3 to 6 months later or a year later. So there's this desire to want to know continually, are cases coming back, and what's happening with the case management of the cases that are resolving in ADR.
Great pearls. So we didn't mention this, but you may have seen up on our desk that each of us have these nice, beautiful colored sheets. You actually have them in your notebooks as the cheat sheets for what are the sort of the pieces that came out from the research, and they're fabulously done and really, really helpful and succinct about the outcomes of the research. So if you haven't found them yet, I encourage you to find them, and then, as Maureen said, share them widely with your colleagues, because I was talking with Toby earlier, and I said, judges like to talk to other judges, lawyers like to talk to other lawyers, judges will sometimes then talk to lawyers, but beyond that, it doesn't go much further. And so, I encourage you to do that peer-to-peer to share these kinds of things, because I know there are lots more judges in district court than are sitting in this room here today. So your work is cut out for you. So here are a couple of things that for me, I just wanted to say in summary about what the research, the importance that I took out of it. First of all, the validation for court-connected programs. I think that Maureen is exactly right. It does give us the ability then to be bold in saying, well, maybe we want to be a bit more directive about how people get into these processes, into mediation in particular, because they may not choose it, but if we encourage them to be there so long as, and big caveat here, that what happens in that room is consistent with what is good mediation practice as demonstrated in this research. So as long as what's happening in there is the elicitive, reflective mediation, that it probably, courts can be a bit bolder, court administration could be a bit bolder about how people get in there. We've already touched on this, so I will just say it briefly, the amount of time mediation takes, and to figuring out how do we allow for and provide for that amount of time for the good mediation to happen. I won't say anything more about joint session versus caucus, although I think it is critical. In terms of ethical standards, I've spent a lot of time thinking about mediator ethical standards, and I share Marvin's passion around we need to be bolder. We as an ADR community need to be clearer about what is mediation and what is something that is not mediation. It's not that it's a bad process, it's not that it's not a valuable process, it's all of those things. It's just not mediation. And I really, really hope that there is now an impetus to be a bit bolder about carving this out and being clear, because I think we don't do anyone any service by being wishy-washy and saying, well, it's all good, and it all counts, and it's, whatever. It doesn't. It isn't all the same, and we should be bold about saying that. There's some really, really interesting stuff about mediator qualifications and experience. And so I encourage you to take a look at that, and there's some mixed results actually about experience. Experienced mediators were positively correlated with less likely for the parties to return to court, but there was a negative correlation between the parties feeling heard and understood. As someone who ran programs for a while, that's actually not all that surprising to me, because I think that things happen when you have experience as a mediator. One is that you become better at it. We know that there's a certain learning curve to becoming good at mediation. And we also know that people sometimes become complacent in their mediations, and they're just like, oh yeah, I know this kind of case. Oh yeah, this is one of those, and I don't really need, I can just help them to kind of, this is what you need to do. I've seen these before. And so how do we, I think it's really a challenge for administrators to think about how do we keep mediators fresh? How do we keep them not kind of falling over the edge on that experience of, oh yeah, I know it all already, but keep them still clinging and yearning to learn more and not thinking that they know it all. For those, your colleagues that went to the session with the family folks heard from Nancy Welsh, who is a real expert on procedural justice. And so I'm just going to say that that's really, there's some important pieces here about parties being heard and understood that supports a lot of the research around procedural justice. That is really an important tie that we should be looking at more closely. And then finally, just to say, in terms of more questions that we have, I think, Maureen hit on this. I share the wish that the circuit study was more robust and we'll be able to say that the findings from district court actually spill over and apply in circuit court cases, that people don't, I fear that people will diminish and say, nah, it doesn't count for these kinds of things. And I would love to see more research on the impact of attorneys' presence in mediation and how there weren't sufficient numbers to tease out some of these things. So again, kudos to all of you for the work that you've done, you continue to do. We all are watching Maryland closely and will continue to do so. And thanks for both the panelists for being here and all of you and your wonderful discussion for this session. Hope it's been helpful.
Thank you.